The order, therefore, will read as follows. The contents of Exhibits PPP and QQQ may be published in accordance with the agreement between the defense attorneys and the media legal representatives. This order is retrospective from Friday, the 4th of July, 2014.
Remember, we dealt on Thursday with you being the treating physician and giving expert evidence on behalf of the accused. Can you remember that?
Yes, my lady, I can.
Now, you said that you don't think there is a conflict of interest to be able to do that.
My lady, I believe my report and my submission and my being here is as objective as I can be, and I acknowledge that I am his treating physician, and wherever I can, I've backed up my representation with scientific evidence.
This flight or fight response is a normal physiological response, and it's present in all people.
It is indeed.
Now, even on the objective facts, there was at least an option for the accused to flee, even walk out of the room. Am I right? On the night of the incident.
There indeed is that option.
Yes.
I would like to say that he is able to flee in the best possible way that he is able to flee. Might be very different, and as I've explained, the ability to flee like we would normally flee, as in you or I, is different. I don't want that to be considered that I've answered that question, that he can flee and move rapidly like any of us can.
He can walk out the door of the bedroom. Walk.
He could walk like he could walk.
Yes.
At his pace, with his limitations, yes.
Indeed. He could walk at the same pace that he walked earlier that evening to brush his teeth in the bathroom. He could walk out the main bedroom door. That was available, that option.
Yes.
You view your evidence before court as being objective as you can be.
Yes.
You've never once considered that the accused version might be a lie.
So, sorry, I didn't hear that.
You've never considered that the accused version might be a lie.
No, I think that's the wrong inference. Obviously, I have.
You have.
Yes.
That whatever he said was a lie. Did you consider that?
My lady, I'm involved in a court case here where there are two sides. There is state's case and there's the defense case. Clearly, I've considered that there are two sides to this.
But you never addressed the state's case in your report?
In my report?
Yeah. Or in your evidence?
I'm not quite sure what you mean.
No, but did you at least in your report say that based on the state's case, there is no that my evidence would not be important because the flight and fight response would not be applicable?
No, because, my lady, I know that any report that I give is open to cross-examination, and you would ask me anything that you were unclear on.
Yeah, so the answer is you never addressed this in your report, and neither did you do it in your evidence in chief.
I never addressed the state's case in my evidence in chief.
Vulnerability should be viewed in the context of the person, am I right?
The person and the situation.
Yes. In this instance, we found somebody with the means to protect himself by living in a security complex and with an alarm system in his house at least. Am I right?
Yes.
Okay. We also have a person with a big support group around him, which include family, am I right? And friends?
Yes.
And even you're part of his support group to look after his health.
That is correct.
That whole scenario mitigates his vulnerability in his context.
I disagree strongly.
If Mr. Pistorius was vulnerable on that night, he armed himself. Am I right?
He did.
At least you will concede. With a gun in hand, he's less vulnerable.
He might indeed be less vulnerable, but how much less vulnerable I do not know. And I can't think if that would reduce his vulnerability. Absolutely.
Do you know that the accused's hobby is shooting? One of his hobbies.
I am aware of that, my lady.
And that he would, well, that he would go to the shooting range and he would shoot at the shooting range.
I know so.
And I'm certain you saw the video where he shot the watermelon at the shooting range.
I did.
Now, those sounds would not startle him, would it?
Not necessarily, sir.
Not necessarily. So is it possible that those sounds would startle him?
My lady, as I understand this phenomenon, if one is expecting a sound and is in control of that sound, then it does not have the same startle response as if you are not expecting a sound.
Good. That is the answer I wanted. He said that he presented with anxiety, coupled with fear.
Yes.
This resulted in a significant flight and fight response.
Yes.
He demonstrated being hypervigilant,
Yes.
as an exaggerated startle response,
Yes.
and as hypersensitive sound.
Yes.
That is the man that we're dealing with.
Yes.
He's a danger to society then, because that caused him to kill someone.
I cannot say that, my lady.
But just look at it. Have you, as far as you're concerned, that is the accused before court. And that led, on your version, to the killing of the deceased.
My lady, that I cannot make that statement. I have got no wherewithal to make a statement that he is a danger to society.
Your focus in your discussion with the accused was sounds. Am I right?
Yes.
You've identified 3.
Yes.
I asked you if he ever said to you that he heard movement inside the toilet.
No.
You say he never did.
He never did.
Okay. Based on the accused version, if the court would accept the accused version, not the state's version, the accused version, you understand that?
Yes.
He, with intention to kill, shot the person behind the door. That's what he wanted to do, and that's what he did. And
Yes.
I put to you that your evidence in no way affects his intention on the night. You have no comment?
But is it my job to do that? Is that not the court's job to do that?
Do you want to respond to what I just put to you? Yes or no? You're an expert, sir. You can say, I don't want to respond, that's fine.
From what I understand, my lady, it was his intention to shoot. That's how I understand it.
I've nothing further. Thank you, lady.
This is probably the last witness. We just need some discussions, and we need just to have a discussion with Dr. Kotze. We have not consulted with her before. She's present today. So I think that's an opportune time. May we stand till 2 o'clock just to make sure that we do not call further witnesses.
May I, my lady, whilst I'm listening to what Mr. Roo is saying, Dr. Kotze is clearly the state's witness, a state psychiatrist. I do not see how Mr. Roo now intends consulting with the state psychiatrist.
The report is one-pager. If the defense really wants to clarify any issue contained in that report, that is Exhibit PPP, all they have to do is to consult Dr. Fine. In my view, no basis has been laid for the request to consult with Dr. Kotze. For that reason, my ruling is that the defense is not permitted to consult with Dr. Kotze.